So this is the bill. It's called the Civil Liberties Act of 1987. I'm going to go through the law and the bill. I'm not going to read both. The law, um, is based on the bill, right? So I'm just going to go and read through what became law. Um, and I just want to show y'all you can actually look at the bill and the bill history. Um, so continue reading, for example. So you can look at the number of co-sponsors. So we can look at who co-sponsored the bill. Let's pull it at 166 co-sponsors, 138 Democrats, 28 Republicans, not including its sponsor. It was co-sponsored by, its primary sponsor was Thomas Foley, a Democrat from Washington, District 5, in the House of Representatives. HR 442. So HR 442 basically became this statute we're going to read through, which is called the Japanese ancestry. It's like Japanese ancestry and let me pull up the exact language. Title One, Civil Liberties Act of 1988. Title One, United States citizens of Japanese ancestry and resident Japanese aliens. So I'm going to read through the entire bill, and then we're going to go through the important parts about eligibility, and then um, just have a conversation in general, and also about how much they got paid and how it was all put in one bill. So let's get started. So, short title. This title may be cited as the Civil Liberties Act of 1988, Section 102, Remedies with Respect to Criminal Convictions. A review of convictions. The Attorney General is requested to review any case in which an individual, excuse me, living on the date of the enactment of this act was, while a United States citizen or permanent resident alien of Japanese ancestry, convicted of a violation of 1. Executive Order numbered 9066, dated February 19, 1942. 2. The act entitled An Act to Provide a Penalty for Violation of Restrictions or Orders with respect to persons entering, remaining in, leaving, or committing any act in military areas or zones approved March 21st, 1942. Third, any other executive order, presidential proclamation, law of the United States, directive of the armed forces of the United States, or other action taken by or on behalf of the United States or its agents, representatives, officers, or employees respecting the evacuation, relocation, or internment of individuals solely on the basis of Japanese ancestry, on account of the refusal by such individual during the evacuation, relocation, and internment period to accept treatment which discriminated against the individual on the basis of the individual's Japanese ancestry. B. Recommendations for pardons. Based upon any review under subsection A, the Attorney General is requested to recommend to the President for pardon consideration those convictions which the Attorney General considers appropriate. C. Action by the President. In consideration of the statement of the Congress set forth in Section 2A, the President is requested to offer pardons to any individuals recommended by the Attorney General under subsection B. Section 103. Considerations of Commission findings by departments and agencies. A. Review of applications by eligible individuals. So this is the first time eligibility is mentioned, but it's not the last. So listen carefully. Review of applications by eligible individuals. Each department and agency of the United States government shall review with. Actually, let me put the link in the Jumbotron too, so if y'all want to have a copy of the link, y'all be able to have a copy of the link too. It's in the chat now, and I'm just putting the Jumbotron. But yeah, let me keep going. Okay, review of applicants by eligible individuals. Each department and agency of the United States government shall review with Liberality, giving full consideration to the findings of the Commission and the statement of the Congress set forth in Section 2A. Any application by an eligible individual for the restitution of any position, status, or entitlement lost in whole or in part because of any disciplinary act of the United States government against such individual which was based upon the individual's Japanese ancestry and which occurred during the evacuation, relocation, and internment period. B. No new authority created. Subsection A does not create any authority to grant restitution described in that subsection or establish any eligibility to apply for such restitution. Section 104, Trust Fund. A. Establishment. There is established in the Treasury of the United States the Civil Liberties Public Education Fund, which shall be administered by the Secretary of the Treasury. So this goes to the conversation that's been happening recently about the Freedmen's Bureau and the Freedmen's Bank. Even within the Japanese reparations, they created the Civil Liberties Public Education Fund, which became administered by the Secretary of the Treasury, which a lot of people in our community would critique because it was not headed by a freedman, for example, or wasn't headed by the person who the harm was done to. You know what I mean? So, or someone of the same lineage. Um, so, just to point that out. B. Investment of amounts in the fund. Amounts in the fund shall be invested in accordance with Section 9702 of Title 31 United States Code. C. Uses of the fund. Amounts in the fund shall be available only for disbursement by the Attorney General under Section 105 and by the Board under Section 106. That's another interesting thing, right? They're saying that the Attorney General will be the one who determines the disbursement of the money. So you have the U.S. Secretary of the Treasury, who they say will um, administer the Civil Liberties Public Education Fund, but the Attorney General will be the one in control of the disbursement of funds. D. Termination. The fund shall terminate not later than the earlier of the date on which any amount has been expended from the fund, which is equal to the amount authorized to be appropriated to the fund by subsection E, and any income earned on such amount or 10 years after the date of the enactment of this act. If all of the amounts in the fund have not been expended by the end of the last 10-year period, investments of amounts in the fund shall be liquidated, and receipts thereof deposited in the fund, and all funds remaining in the fund shall be deposited in the miscellaneous receipts amount in the Treasury. Basically saying if no one claims their money within 10 years, it'll be, um, you know, returned back to the Treasury Department. E. Authorization of appropriation. So this is what I'm talking about. They already authorized funds in their bill. Authorization of appropriations. There are authorized to be appropriated to the fund $1.25 billion, of which not more than 500 million may be appropriated for any fiscal year. Any amounts appropriated pursuant to the section are authorized to remain available until expended. So they already had their amount, $1.25 billion. Um, Section 105, Restitution. A. Location and payment of eligible individuals. So this is the second mention of eligibility. So, 1. In general, subject to paragraph 6, the Attorney General shall, subject to the availability of funds appropriated to the fund for such purpose, pay out of the fund to each eligible individual the sum of $20,000 unless such individual refuses, in the manner described in paragraph 4, to accept the payment. So again, they already had the appropriations done and how much they were going to award to each person in this bill. 2. Location of eligible individuals. The Attorney General shall identify and locate, without requiring any application for payment and using records already in the possession of the United States government, each eligible individual. I'm going to repeat this because this is actually really important and we should include it in ours. Okay, so check this out. The Attorney General shall identify and locate without requiring any application for payment and using records already in the possession of the United States government, each eligible individual, which means that it is the duty of the government to use all of its available resources in order to ascertain who are the eligible recipients, not the other way around. It doesn't mean you can't come with your own documents. In our case, I think it would be helpful, but it would also mean it is beholden on the government to use all of their resources to bring to bear the history that may not be available in public records to make clear that who are the eligible individuals. So I really like that part. Um, the Attorney General should use funds and resources available to the Attorney General, including those described in Section C, to attempt to complete such identification and location within 12 months after the date of this act. Any eligible individual may notify the Attorney General that such individual is an eligible individual, kind of like what I just said. You know what I mean? If you know you're eligible, you can just should be able to apply in that sense, and may provide documentation therefore. The Attorney General shall designate an officer or employee to whom such notification and documentation may be sent, shall maintain a list of all individuals who submit such notification and documentation, and shall, subject to all availability of funds appropriated for such purpose, encourage through a public awareness campaign each eligible individual to submit his or her current address to such officer or employee. To the extent that resources referred to in the second sentence of this paragraph are not sufficient to complete the identification and location of all eligible individuals, they are authorized to be appropriated such sums as may be necessary for such purpose. Which is basically saying if we didn't budget enough for you to find every eligible individual, then you are authorized to spend however much money is necessary to do so. Um, in any case, the identification and location of all eligible individuals shall be completed within 12 months after the appropriations of funds under the preceding sentence, which is interesting because they're saying all people who are eligible must be identified within 12 months. Um, you know what I mean? That's kind of a strict timeline um, in terms of like what they're expecting. Um, which also, I wouldn't encourage us having a 12-month deadline like that, but I would say something like, um, it is important that we start tracing our lineage so that we're ready. We have this hashtag like prepare for repair. You know what I mean? So get ready for reparations. Okay. Notice from the Attorney General. The Attorney General shall, when funds are appropriated to the fund for payments to an eligible individual under this section, notify that eligible individual in writing of his or her eligibility for payment under this section. Such notice shall inform the eligible individual that A. Acceptance of payment under this section shall be in full satisfaction of all claims against the United States arising out of acts described in Section 1082B, and B, each eligible individual who does not refuse in the manner described in paragraph 4 to accept payment under this section within 18 months after receiving such written notice shall be deemed to have accepted payment for such purposes of paragraph 5. So they mentioned a key word in here, which is satisfaction, and that's connected to the definition, one of the 5 definitions of reparations, and one of which is satisfaction. So they're kind of saying if you accept this reparations check, you are saying that you're satisfied and that you will have no further claim, essentially. 4. Effect of refusal to accept payment. If an eligible individual refuses, in a written document filed with the Attorney General, to accept any payment under this section, the amount of such payment shall remain in the fund, and no payment may be made under this section to such individual at any time after such refusal. So they're kind of saying you can't refuse it and then come back, the next day and say you want it. 5. Payment in full settlement of claims against the United States. The acceptance of payment by any eligible individual under this section shall be in full satisfaction of all claims against the United States arising out of acts described in Section 108(2)(b). This paragraph shall apply to any eligible individual who does not refuse in the manner described in paragraph 4 to accept payment under the section within 18 months after the receiving of notification from the Attorney General referred to in paragraph 3. 6. Exclusion of certain individuals. Now, this is another time where they mention eligibility, but this is in the context of people who they're not going to deem eligible. Excuse me. So, exclusion of certain individuals. No payment may be made under this section to any individual who, after September 1st, 1987, accepts payment pursuant to an award of a final judgment or a settlement on a claim against the United States for acts described in Section 108(2)(b), or to any surviving spouse, child, or parent of such individual to whom paragraph 6 applies. 7. Payments in the case of deceased persons. A. In the case of an eligible individual who is deceased at the time of the payment under this section, such payment shall be made only as follows. I. If the eligible individual is survived by a spouse who is living at the time of payment, such payment shall be made to such surviving spouse. II. If there is no surviving spouse described in clause I, such payment shall be made in equal shares to all children of the eligible individual who are living at the time of payment. And then III, if there is no surviving spouse described in clause I, and if there is no children described in clause II, such payment shall be made in equal shares to the parents of the eligible individual who are living at the time of payment. If there is no surviving spouse, children, or parents described in clauses II, and III, the amount of such payment shall remain in the fund and may be used only for the purposes set forth in Section 106(b). B. After the death of an eligible individual, this subsection and subsection C and F shall apply to the individual or individuals specified in paragraph A, to whom payment under this section will be made to the same extent as such subsections apply to the eligible individual. C. For purposes of this paragraph, I, the spouse of an eligible individual, means a wife or husband of an eligible individual who is married to that eligible individual for at least 1 year immediately before the death of the eligible individual. III, a child of an eligible individual includes a recognized natural child, a stepchild who lived with the eligible individual in regular parent-child relationship, and an adopted child. And III, a parent of an eligible individual, includes fathers and mothers through adoption. That's interesting. B. Order of payments. The attorney shall endeavor to make payments under the section to eligible individuals in the order of the date of birth, with the oldest individual on the date of the enactment of this act, or if applicable, that individual's survivors under paragraph 6, receiving full payment first, until all eligible individuals have received payment in full. That's interesting. It's not exactly how we suggested it with our pro rata lifetime payments, but they did say at least they're doing it in order of age, and they have some consideration for people who are older in age and are more likely to pass away, right? So that. At least they had some consideration for that. C. Resources for locating eligible individuals. So again, another mention of eligibility. In attempting to locate any eligible individual, the Attorney General may use any facility or resource of any public or nonprofit organization or any other record, document, or information that may be made available to the Attorney General. D. The administrative costs not paid from the fund. No cost incurred by the Attorney General in carrying out this section shall be paid from the fund or set off against, or otherwise deducted from any payment under this section to any eligible individual. Meaning like the process for them finding eligible individuals should not take away from the amount appropriated for the fund. Termination of duties of the Attorney General. The duties of the Attorney General under this section shall cease when the fund terminates. F. Clarification of treatment of payments under other laws. Amounts paid to eligible individuals under this section 1 shall be treated for purposes of the internal revenue laws of the United States as damages for human suffering, and 2 shall not be included as income or resources for purposes of determining eligibility to receive benefits described in Section 3803 C2C of Title 31 United States Code, or the amount of such benefits. That's kind of saying, the IRS can't tax you on your money that you get from the payment, and they say it's because it's for it's damages for human suffering caused by the United States. Section 106, Board of Directors of the Fund. So again, this goes into like how people are talking about like a Freedmen Bureau and a Freedmen Bank. This is how the Japanese had their structure. So we've already talked about the fund is being administered by the U.S. Treasury Secretary, and the Attorney General is the one who determines the disbursement of the funds. All right, so let's read this. Section 106, Board of Directors of the Fund. A. Establishment. There is established the Civil Liberties Public Education Fund Board of Directors, which shall be responsible for making disbursements from the fund in the manner provided in this section. B. Uses of the fund. The board may make disbursements from the fund only 1. To sponsor research and public educational activities, and to publish and distribute the hearings, findings, and recommendations of the Commission, so that the events surrounding the evacuation, relocation, and internment of United States citizens and permanent resident aliens of Japanese ancestry will be remembered, and so that the causes and circumstances of this and similar events may be illuminated and understood. And 2. For responsible administrative expenses of the board, including expenses incurred under subsection C3, D, and E. C. Membership. 1. Appointment. The board shall be composed of 9 members appointed by the President, by and with the advice and consent of the Senate, from individuals who are not officers or employees of the United States government. 2. Terms. A. Except as provided in subparagraphs B and C, members shall be appointed for terms of 3 years. B. Of the members first appointed, I. 5 shall be appointed for terms of 3 years, and II. 4 shall be appointed for the terms of 2 years, as designated by the President at the time of appointment. C. Any member appointed to fill a vacancy occurring before the expiration of the term for which such member's predecessor was appointed shall be appointed only for the remainder of such term. A member may serve after the expiration of such member's term until such member's successor has taken office. No individual may be appointed as a member for more than 2 consecutive terms. C. Compensation. Members of the board shall serve without pay, except that members of the board shall be entitled to reimbursement for travel, subsistence, and other necessary expenses incurred by them in carrying out the functions of the board in the same manner as persons employed intermittently in the United States government are allowed expenses under Section 5703, Title 5, United States Code. 4. Quorum. 5 members of the board shall constitute a quorum, but a lesser number may hold hearings. 5. Chair. The chair of the board shall be elected by the members of the board. D. Director and staff. 1. Director. The board shall have a director who shall be appointed by the board. 2. Additional staff. The board may appoint and fix the pay of such additional staff as it may require. 3. Applicability of civil service laws. The director and the additional staff of the board may be appointed without regard to Section 5311B of Title 5 United States Code, and without regard to the provisions of such title governing appointments in the competitive service, and may be paid without regard to the provisions of Chapter 51 and Subchapter 3 of Chapter 53 of such title relating to classification and general schedule pay rates, except that the compensation of any employee of the board may not exceed a rate equivalent to the minimum rate of basic pay payable for GS 18 of the general schedule under Section 5332A of such title. E. Administrative support services. The Administrator of General Services shall provide to the Board on a reimbursable basis such administrative support services as the Board may request. F. Gifts and donations. The Board may accept, use, and dispose of gifts or donations of services or property for purpose authorized under subsection B. G. Annual reports. Not later than 12 months after the first meeting of the Board, every 12 months thereafter, the Board shall transmit to the President and to each House of the Congress a report describing the activities of the Board. H. Termination. 90 days after the termination of the fund, the Board shall terminate, and all obligations of the Board under this section shall cease. Section 107. Documents relating to the interment. So this kind of goes into kind of like how we're tracing our ancestry and looking for documentation, so it's kind of relevant. Okay. Section 107. Documents relating to the interment. A. Preservation of documents in national archives. All documents, personal testimony, and all other records created or received by the Commission during its inquiry shall be kept and maintained by the Archivist of the United States, who shall preserve such documents, testimony, and records in the National Archives of the United States. The Archivist, how you doing, Marcus? The Archivist shall make such documents, testimony, and records available to the public for such purposes. B. Public availability of certain records of the House of Representatives. 1. The Clerk of the House of Representatives is authorized to permit the Archivist of the United States to make available for use records of the House, not classified for national security purposes, which have been in existence for not less than 30 years, relating to the evacuation, relocation, and internment of individuals during the evacuation, relocation, and internment period. 2. This subsection is enacted as an exercise of the rulemaking power of the House of Representatives, but is applicable only with respect to the availability of records to which it applies, and supersedes other rules only to the extent that the time limitation established by this section with respect to such records is specifically inconsistent with such rules, and is enacted with full recognition of the constitutional right of the House to change its rules at any time in the same manner and to the same extent as in the case of any other rule of the House. Section 108. Definitions. For the purpose of this title, 1. The term evacuation, relocation, and internment period means the period beginning on December 7, 1941 and ending on June 30th, 1946. 2. The term eligible individual. Okay, again, this is another time where they mention eligible individual and they get a little bit more into the details, so listen carefully. The term eligible individual means any individual of Japanese ancestry who is living on the date of the enactment of this act and who, during the evacuation, relocation, and internment period, A, was a United States citizen or permanent resident alien, and B, was confined, held in custody, relocated, or otherwise deprived of liberty or property as a result of 1. Executive Order numbered 9066, dated February 19, 1942. 2. The act entitled An Act to Provide a Penalty for Violation of Restrictions or Orders with Respect to Persons Entering, Remaining in, Leaving, or Committing any act in military areas or zones approved March 21st, 1942. Or 3. Any other executive order, presidential proclamation, law of the United States, directive of directive of the armed forces of the United States, or other action taken by or on behalf of the United States or its agents, representatives, officers, or employees respecting the evacuation, relocation, or internment of individuals solely on the basis of Japanese ancestry, or II, was enrolled on the records of the United States government during the period beginning on December 7, 1941, and ending on June 30th, 1946, as being in a prohibited military zone, except that the term eligible individual does not include any individual who, during the period beginning on December 7th, 1941, and ending on September 2nd, 1945, relocated to a country while the United States was at war with that country. The term permanent resident alien means an alien lawfully admitted into the United States for permanent residence. 4. The term fund means the Civil Liberties Public Education Fund established in Section 104. 5. The term board means the Civil Liberties Public Education Fund Board of Directors established in Section 106. And 6. The term commission means the Commission on Wartime Relocation and Internment of Civilians established by the Commission on Wartime Relocation and Internment of Civilians Act. Section 109. This is the last section. Compliance with Budget Act. No authority under this title to enter into contracts or to make payments shall be effective in any fiscal year except to such extent and in such amounts as are provided in advance in appropriations acts. In any fiscal year, total benefits conferred by this title shall be limited to an amount not in excess of their appropriations for such fiscal year. Any provision of this title which directly or indirectly authorizes the enactment of new budget authority shall be effective only for the fiscal year 1989 and thereafter. So that's the entire Japanese internment I'm sorry, the reparations law that gave the Japanese reparations for their internment, and it's called the Civil Liberties Act of 1988. Um, so yeah, what are your thoughts on this? We read through a lot of the eligibility requirements they have. I'll send some mics out for people to speak. But yeah, they talk about eligibility requirements. They talk about who's not eligible. They talk about appropriations and how much they're going to give. What are your thoughts?
And I just think that it was really detailed, especially like with the eligibility and like who wasn't eligible, and then also it's interesting how they allocated funds for education, just everything that encompassed the bill. I think it's a blueprint to what we want to see happen. So yeah, man, thanks for finding this bill. You sent it to me earlier. I didn't get a chance to read it, but yeah, man, thanks for reading this out. Very informal, so it kind of lays out where we should be headed. It seems like we're headed in the right path. It just, looking at this, it kind of gives you like the finer details of what we should be looking to put in one of our bills. So yeah, man, thanks for that. Yeah.
Of course, yeah. I found it like really enlightening. Like you said, it's very specific, very detailed. Um, and we need to make sure ours is as specific and detailed. Excuse me, as specific and detailed. And so, you know, in addition, they also talk about who's not eligible, and they also talk about things like appropriations. They talk about certain things that we may not like how it's structured, but they do talk about a fund, a trust fund, right? And they do talk about a board of directors over that fund, and they talk about presidential appointments and Senate confirmations. They talk about all of that, right?
Yeah, I think the most surprising part was that the attorney general is responsible. I think that was kind of like the highlight. It's kind of not on us to prove who we are. It's up to them to already. I mean, they know who we are. They dropped those Freeman documents, so they know who we are. They've been knew who we are. So that was kind of like one of the most interesting parts of that bill.
I'd have to agree. That's probably one of my favorite lines. Let me see if I can pull it up real quick to quote it for the room. But it was basically talking about like they need to do the work to help find us, and um, it's they don't have anything against us coming to them for if we think we're eligible, but they basically made it beholden on them to do the work and use it all the government documents they have available. Let me see if I can find it.
That's what I thought about, but go ahead, cool.
Yeah, no, you're good. Let me see if I can find that quote real quick. Give me 1 second. Okay, here we go.
Go ahead, Eric.
Okay, location of eligible individuals. The Attorney General shall identify and locate without requiring any application for payment and using records already in the possession of the United States government each eligible individual. So that's a pretty powerful line, you know what I mean? Like, we need to have that clause in ours because it means that they are not only responsible for a lot of it, obviously we can help them, but by doing the work ourselves, but like they still have to do the work. It's up to them to find who's eligible using all of their available resources that may not be public that we don't even have access to.
Yeah, you remember the task force in California, and we brought it up in a space. Of the people are 60%.
He said it was 80K out of the 120K, which is around 67%, 2/3.
Right. So that's that part when you read that. So basically what happened, the federal government, let's say, it was their responsibility to determine eligibility and to find those that were eligible. So if we leave this up to the federal government, they only paid out 67% of all that were possibly eligible. That right there. And I know, see, I always believe that when stuff stands out to you, it's for a reason. And when you read that, I was like, well, damn. He himself admitted that the Japanese reparations only was really a failing grade instituted by the United States government. They only paid out a possible 67% of everyone who possibly was eligible. Now, it could be for some of those disqualification reasons, but to me, that stood out.
Yeah, so when I was looking up the bill and I was searching the bill, it said something like it was only eligible, and you can read it in the bill. It's basically only eligible for U.S. citizens and permanent residents of the U.S. at the time. So basically, anyone who didn't meet that criteria, which out of the 120K that were eligible based on being interned, only 80K met that requirement of being a U.S. citizen or being a permanent resident in the United States. So yeah, that would be 80%. So now another question could be like, out of that percentage that met that requirement, you could ask another question like, did all of them get paid out, or was there money left over? Like those are questions I don't necessarily have answers to right now, but those are good ways we can look deeper. Um, go for it, Hilda, or go for Spine, sorry, and then Hilda.
No, go ahead. Is it on me?
Yeah, go for it, Hilda.
Yeah, I just wanted to know, did they have a commission prior to this bill? Because I'm wondering where did they get the total amount that was in the bill, the $1.25 billion. So
Yeah,
was there a commission that they had prior to the writing of this bill?
Yeah, I asked my little AI bot. You should check out either ChatGPT or Write Sonic. Really cool. I asked like, did they have a study bill? It said yes. The Civil Liberties Act of 1988 contained a provision for a study of the internment of Japanese Americans during World War II. The Commission on Wartime Relocation and Internment of Civilians was created to determine the facts and circumstances surrounding the internment and to make recommendations regarding compensation and a public education program. After 2 years of hearings and research, The commission made a formal apology and recommended that Congress pass a bill to provide reparations to the internees and their families. The commission's findings were instrumental in the passage of the Civil Liberties Act of 1988. So I do want to actually, in the future, go and read the study bill as well. Um, but it's just amazing because what we have to what we have to do either on the state level in California and on the federal level is once, let's say, California finishes on July 1st, 2023, after they finish, it will still need to be passed by the state legislature. Their recommendations will need to be taken to the state legislature, turned into a new bill with appropriations that will need to be passed and then signed by the governor. The same thing is true for reparations at the federal level. Even if HR 40 or S40, which aren't perfect, or passed, or an executive order is signed to construct the commission, once the commission completes its work, it will still need to submit their findings to Congress. And then Congress will then need to create a new bill that then is passed to actually do the appropriations. Go for AMK, and then Super Sean.
Yeah, I missed the part. Um, how long did it take the Japanese to do reparations? Like, how long did they have to campaign for it? Was it
Well,
directly
it was
after World War II or?
well, it was 1941 is when they were interned. It sounds like, and then at least they started their internment, and then it sounded like that internment lasted a few years, and then after that, um, they didn't get a commission established until the Commission on Wartime Relocation. Actually, let me see when that was established. That's a good question. But they're saying it took 2 years for them to do their work. But let's see when it was established.
I put it in the
19,
jumbo time.
yeah, 1980. Thank you. So it was established in 1980, and then you had 2 years of research apparently by that commission, and then after that, the Civil Liberties Act doesn't get passed until 1988, surprisingly. So I don't know. Seems like there might have been an 8 year gap between the study, or a 6 year gap. Oh no, yeah, 8 years because they finished in 19. No, well, they established the commission in 1980. It took 2 years, so they finished in 1982. About, so yeah, 6 years. It sounds like between the end of the study and the passing of a bill to provide the actual compensation. That seems strange. I would like to verify that for sure, but just going off the numbers, it's the Civil Liberties Act of 1988, right? And the commission ended in 1982. So, you know.
Well, it could make sense because you're only talking about 100,000 people, you know.
Yeah,
So
maybe based on the bill, it took all the attorney
so
general to find those people that long or something.
that was my only question. Thanks, man.
Yeah, of course. Um, super. Go for it.
You know what? What else? I'm sorry, Super. Go ahead.
What has me a little thrown off about this is, I mean, and I've heard about this. I've spoken with people about this in the past. Like the last conversation I had about this 2 years ago. The Japanese, they with the rest of the AA, whatever community, the Asian community, whatever. These people actively fight against us, but their whole campaign for their reparations claim or restorative justice claim or whatever you want to call it was damn near cut and paste off of the campaigns we were, that black people were holding in that time, during that time and before. So like they off of everything that we were doing, and they still actively, even up to this day.
Oh no. Jesus Christ. Dang.